Welcome to the Next Level Law Podcast, where we explore innovative strategies to grow and scale your law firm in today's competitive legal landscape. Joining you each week are veterans in the legal space and law firm growth experts Arash Eskandari and Richard Perillo, coming to you with over 18 years of combined experience, successfully transforming legal practices. Our hosts are passionate about helping law firm owners take their business to the next level. If you want to exponentially increase your client base, revenue, efficiency, and profitability, you're in the right place. Stick around as your hosts dive into actionable insights and proven methods tailored specifically to help your law firm ascend to new heights. Time to get down to business.
Welcome to another episode of the Next Level Law Podcast. I'm Richard Perillo, and the podcast today is sponsored by Vertical 10. Vertical 10 is your full-service digital marketing agency exclusively for attorneys, providing SEO, Facebook, and Google marketing services designed to bring quality clients to your firm. Visit vertical10.com to find out more information and see if your law firm is a good fit for our Case Accelerator program. We are very pleased to be joined today by attorney Jeremy Ramsey out of Loves Park, Illinois. Jeremy specializes in estate planning, will and probate, along with real estate and contract law. Jeremy, thank you for hopping on this afternoon.
Thanks for having me.
Yeah, no, fantastic. So, like we talked about, a little bit before, before the podcast started, Jeremy, what we want to start off the podcast by having you kind of discuss a little bit of your journey. What motivated you to, initially, hop into the legal field. And, and I know we talked a few minutes earlier about, your experience as a prosecutor, but if you don't mind sharing with our audience a little bit about where your motivations came from and why you made some of those initial early choices like you did.
Sure. I can tell you, I knew I wanted to be a lawyer very early on. I can remember being like 12 or 13 years old and thinking I wanted to go to law school and become a lawyer. One of the stories I tell was I had a grandfather on my paternal side. He was a small businessman, so he owned a small town, had a business, had apartment buildings, just an entrepreneur himself. One day I overheard a conversation between my grandfather and my father. My grandfather was talking about the fact that he was having problems with tenants that were not paying rent, that were, destroying his apartment building. He went and hired a local attorney to get him evicted. Apparently, it said he paid a lot of money to the attorney and didn't get the tenants evicted. So he was having frustration of saying, well, what's the point of having an attorney? You give them all that money and they don't help you. And that was a big motivator for me to say, there's an opportunity to do something where, a little guy needs help, and goes to somebody for help. And instead of getting the help he deserved, just ended up spending a lot of money. And I thought that was wrong. And that was a big motivator for me to saying, well, if I could go to law school and do things where I would help everyday people, common people. I didn't grow up in a rich family. Dad was a truck driver. Mom was a factory worker, housewife. I was always motivated to help people who are, regular run of life, blue collar people, to get through stresses and trials that they were going through.
Perfect. So, you were saying earlier you started off as after law school, you started off in the prosecutor's office. Is that correct?
Correct. Yeah. So in the early 2000s, my first job was as they call them state's attorneys here in Illinois. So assistant state's attorney. It was great. It was I learned more in a few years of being a state's attorney than I ever learned in law school, because I was doing everything: bench trials, jury trials, motion hearings, obviously criminal law. So I did everything from as simple as dog cases, like someone would have their dog running loose or a dog would unfortunately attack a person or another dog. So we'd have prosecutions of those cases, and those were very entertaining, to be quite honest. And then all the way up to like felony level cases. I did a lot of DUI prosecutions. Did a lot of like domestic battery, DUI prosecution, misdemeanors. I did quite a bit of that on the prosecution side. It was a very exciting lifestyle. I mean, you quickly overcame any fears that you have of, having to think on your toes, having to speak in front of people, because I had to obviously speak in front of juries all the time. Was a prosecutor for several years. Then when I left the prosecution role, I became an attorney for the United States Army Reserves. I was a judge advocate. It was something I had wanted to do for a long time. I had a grandfather on my mom's side of the family who was a medic in World War II. In the Army, I greatly admired him for that, and always wanted to have. It was just something I always wanted to do. I always wanted to serve in the military. So I became a judge advocate. And surprisingly enough, the main thing we did as JAGs is we did estate planning. It was very basic. It was like cookie cutter wills, powers of attorney, beneficiaries on life insurance policies in case. The idea was if a soldier was deploying and they didn't sadly make it back, then how did we make sure to take care of their loved ones that were stateside, if something bad happened to them. So that was, I mean, did that for a few years, and enjoyed that. I got the sense that when I did the estate planning for people, it put their minds at ease. So like I was saying before with the story with my grandfather, where it was someone where he was saying, boy, I needed help on this, not too difficult issue, and couldn't find an attorney to do that. So I felt like I was meeting that need with doing the estate planning. People would come to me and say, I'm worried about the future. What happens if I die? What happens to my children? What happens to my house? So I was able to, I do that every day. I mean, I put people's minds at ease where I say, this is what the law says. This is what you should do. Obviously I want to get their picture of what their game plan is for the future, for preparing for their loved ones. And I put things in order so it's much easier on their family when they leave this earth.
So, kind of expanding on that, can you talk a little bit about, and I know each state is different, so let's just kind of talk along like generalities, and I mean, obviously we can kind of, use Illinois as an example, but can you talk about some of the consequences for families that, for whatever reason, maybe it's finances, maybe you got brothers and sisters that don't talk, it could be 100 different variables, right? What are the consequences if they don't see an attorney like yourself, and their parents pass away, and now it's maybe it's in probate, maybe it's in control of the state? Like, what are some of the consequences if someone doesn't sit down with you and go through this this next stage of life plan? What are some of the things that can kind of jump up and bite them in the rear end, so to speak?
Sure. So each state is, estate planning is pretty similar across the states, but each state has a different nuance, different law affiliated with it. I'm licensed in Illinois and Wisconsin because I'm right on the border of the two states, so I have clients in both states, and it's very similar, but there are differences between the two states. The main point is this: if a person doesn't take care of where their assets go when they leave this earth, the state that you reside in will decide that for you. Now, people freak out, and sadly there are companies out there I do not admire, do not respect. I will call them like trust mill companies, where they scare people. They use scare tactics. They use things where they say, oh, if you don't take care of an estate plan, all your hard-earned money, your house, everything, the government's going to take it. That's not true. What happens is when someone dies without at least a will, I mean, you should at least have a will. But if you die with nothing, your estate goes through the probate court process. And probate, I always tell people, probate court is essentially, you go into court as the attorney and you say, John Doe has died. and John Doe had a house, John Doe had bank accounts, John Doe had a car, John Doe had all these different things. If you think that John Doe was going to give you money, or you think John Doe owed you money, we're letting you know right now. We publish in the newspaper, we put notices out, and we say we're going to keep this open for usually the law is that you keep the probate case open for 6 months, and you say starting today and for the next 6 months, the clock's ticking. So if you think John Doe was going to give you money or owed you money, you got 6 months to get in here and stake your claim, because on 6 months and 1 second, you're done. The door's closed. We're out of here. You're not gonna, you're not gonna be able to file your claim anymore. So the main thing there is, well, I always tell people, here's concerns about probate law. One, it's time consuming. So I have many probate cases open. I actually just opened a couple of them last week. Again, in Illinois, we have to keep the probate open for 6 months, but I have never finished a probate in 6 months' time. Not because I'm milking the system or, kicking the can down the road. It's because in general, when I file a probate, I get a 1 year return date from the clerk of courts. Now, in that 1 year time, I'm going to the administrator, the executor, and I'm saying, we got to get stuff done. We got to get the house sold. We got to get accounts liquidated. We got to pay final expenses of the deceased, which can be very, very costly. So so I get billable hours. So if I got billable hours for a year's time, about a year time, that's quite a bit of legal fees. Attorneys can make quite a bit of money in billable hours in probate cases. And if you don't have anything at all, your estate's going to go through probate, and depending on the value. Illinois, anything over $100,000 cumulative is subject to probate laws. In Wisconsin, it's only 50. So Wisconsin gives you less breathing room. So if someone dies with either nothing at all, or if they just have a will, this is something most people don't understand. Most law school students don't understand. Most initial lawyers don't understand. Some veteran lawyers don't understand. A will is an instruction letter to a probate judge. That's all it is. So if all you do is a will, you're almost pretty much guaranteeing your estate's going to be probated. And probate, yep, tell people I have a love-hate relationship with it. I love it because it's a lot of billable hours and yep, can be quite lucrative for an attorney. I hate it because there's a lot of work to do and a lot of hassles and a lot of notices and seeing who files claims and having to go to court regularly to report on things. So I do a lot with my clients and tell them how to avoid probate. And there's really only two ways to avoid probate. One, you put beneficiaries on your accounts, which avoids probate because you're making a contract with your financial institution saying, when I'm gone, here's who you give this money to. And they're obligated by law to give the money to that person or those people. But if you have beneficiaries on your accounts and one of those beneficiaries dies and you don't have a contingent, a backup beneficiary, it's possible it will have to be called back into the probate courtroom to see where that money goes. Second is I've had situations where someone put beneficiaries on all their accounts. They had a will. The person died. There's an executor appointed. The first thing that has to be done when someone dies, you've got to pay their bills, whatever expenses they have, funeral expenses, hospital bills, ambulance bill, nursing home bills. They have to be paid first. If you have an executor who says, well, there's no money in the estate, because people were appointed as beneficiaries and all the checks are cut and I don't have any money to pay the bills. That's a problem because I've had executors reach out to beneficiaries and say, could I have some of that back? So I got to pay a hospital bill or got to pay a funeral bill. And some of those beneficiaries, I've seen it happen firsthand. They go, that check was made to me. I've already cashed it. I've already deposited. I've already spent it. I'm not giving it back. And then you've got lawsuits where the hospitals, funeral homes will file claims against those people saying, you have to give us some of that money. So beneficiaries have downfalls, but they avoid probate. Second, a trust. I do a lot of trusts. A trust is an intelligent thing. A trust is a helpful thing. A trust is a contract that you make with yourself. or somebody else, depending on if you want revocable or irrevocable trust. But trusts where you put your house in the name of your trust, you can put your trust as beneficiary on a lot of your accounts, your non-tax deferred accounts. You can put it as the beneficiary of all accounts, but I prefer trusts are just mostly reserved for non-tax deferred accounts, but that there are some circumstances there where you can avoid that. But trusts, if prepared properly and funded properly, a trust estate does not go through probate, and that's where you should want to be.
So, so looking at that situation, it seems like in the last few minutes, I mean, it's been very, very clear, very concise on how to, how to avoid these pitfalls. Someone comes in, wants to retain you and your firm. Typically, what is the range that your firm charges for, let's, I know that, sometimes you say it can be like, hourly rate, but like if you had to give a ballpark, so what would people be able to expect in terms of, they want to get, their will done, they want to get their estate planning done. What would be like a ballpark figure that your firm looks at in terms of, what those legal fees would be, like best case and then potentially like worst case for, for those potential clients.
So yeah, it's a big range.
Right.
Most estate planning attorneys charge flat fees. We usually don't do bill. If I'm doing a probate or a trust administration, billable hours. But if I'm drafting an estate plan for someone, I find out what they're looking to do, what assets they have, and I try to establish a flat fee for the preparation of the estate plan. Most estate planning attorneys do that because we're not reinventing the wheel. We're doing what people have been doing for a long time. I've done very simple wills and some power of attorneys and living wills, something like that, $300-400. That's very, very basic. That's like they don't have much. They're just wanting something to establish. Well, here's where things go when I pass. Very basic.
Right.
Then on the other end, I've met with clients who want to do irrevocable trusts, who want to do trust for one property here in Illinois, one for another trust for property in Wisconsin. They want to put farmland into generation skipping trusts. So on those, I can go up to fees somewhere around $5,000 to $6,000 for a flat fee. Generally speaking, people are going to fall obviously in the median there, somewhere around, I would say, like a married couple wanting to avoid probate, wanting their house to be safe. You're going to be looking somewhere in like the $2,500 to $3,000 range. Give or take on how complicated they want things to be. Single individuals are going to be less because it's not, when married couples, I'm doing double the work. But yeah, I tell people, look, if you're going to pay $3,500 to do, your estate plan, which avoids probate if you follow the instructions I give, compare that to if you die and nothing's in place, or you just have a will and I'm doing a probate and there's houses to sell and there's accounts to liquidate and there's bills to pay and there's sibling rivalry. I've had probates where I've been paid $25,000-30,000 when all's said and done. Compare that to the cost of a $3,500 well-prepared estate plan. It's kind of a no-brainer.
Well, and then touching on the sibling rivalry, how often do you see sibling rivalry over these estates? Whether it's a small estate, medium estate, large estate. I mean, I'm sure it doesn't necessarily matter, like with everybody wanting to get what they think is rightfully theirs. How often do you see, once mom and dad are deceased, that sibling rivalry occur, and then how often do you see it get nasty and personal?
I'm happy to say that, again, if my clients follow the instructions I give them, and I do give homework to my clients with trust funding, and I help them with it and make sure everything's done properly. If they do that, then I would say less than 10% chance of sibling rivalry. If they do nothing, and I'm meeting with some people this week where dad died, there's no will or anything, and there's multiple children in the family, we're going to have fighting, because several of them are going to say, I want to be the administrator of the estate. They're going to object to each other being administrator. And that's not even, we haven't even gotten into the money part or selling the house.
Right.
Got to do appraisals, got to go to bank accounts, got to go through the house and see. I've had, believe it or not, I've literally had children of deceased clients, not joking, I've had children try to hurt each other because they were arguing over mom and dad's knickknacks. So when you don't plan accordingly, then sibling rivalry situation, which I get quite a bit of billable hours for that, that goes up substantially. I would say 70% of the cases when you don't plan anything, there's going to be sibling rivalry. Again, hopefully the family goes, well, mom and dad have passed. Yeah, this is a bad situation. We don't want to make it worse by fighting over stuff. I always tell people, don't talk about the money. Don't talk about the house. Don't talk about who's getting what until the funeral is over. And that's unfortunate. I've had several times where people are like, we're in the receiving line with the family receiving condolences for a deceased loved one, and someone comes up and says, what's happening with the house? Then emotions are charged. There's going to be fighting. So again, no planning, high percentage of sibling rivalry. Planning well, I would say, again, less than 10%.
Gotcha. Yeah. And I mean, I think it's, and we could say this with everything, but I mean, yeah, I mean, a well thought out, well executed plan by a professional like yourself, like your firm. Yeah, you're going to save over 90% of the headaches. And, I implore those that have, tuned in, Apple, Spotify, wherever you can find your podcasts. You're taking what Jeremy is saying to heart, and yes, sometimes 2,500 or 3,500 or whatever it ends up being for an initial plan may seem, more money than they may have in today's economy, but it is what you're telling us, staving off, 10 times that amount potentially down the road. And so, it's,
Right.
it's definitely something that individuals, okay. So let me ask you another question. When should people, single or married, really start to think about having a conversation with with your firm about, about their estate, about their planning? Like, what's the ideal point in, in a single person or even in a married couple's life to really sit down and talk with you and get this plan laid out?
Simple answer is, as soon as you turn 18, you should have some type of an estate planning document, whether it's just a will and some powers of attorney. When you're 18, you're an adult, legally speaking, and you should have things set out so that if something happens to you, things are taken care of. The two biggest times in life that most of my clients fall into are, one is they're new parents. They say, oh, we just had our first baby, and we're worried about like guardianship. We're worried about, planning for the child in the future in case something happens to one of us. That's a huge group of people that I help right there. But second, and this is probably even larger than that, retirees. So people who are saying, yep, I've put in all my years at work. I'm slowing down. I'm stepping down. I'm retiring. And they go, I'm not going to be on this earth as much as I used to be. So I'm worried about, where's my house going to go? Where are my accounts going to go? Where's my pension going to go? Then, yeah, they start going, clocks kind of ticking. And so I would say the majority of my clients fall in that category. Retirees that just want to make sure everything goes properly to their children without sibling rivalry, without fighting, without all the expenses of a probate court process.
Perfect. Yeah. So, you had mentioned before, and before we had started a little bit in the pre-interview process, and I know, and we definitely appreciate you being very generous with your time. And there's a subject I want to bring up that you also have said that you had handled, in terms of First Amendment and Second Amendment cases. Would you mind, talking to our audience a little bit about? And I know I'm switching gears, but I think, I think with the probate and the estate planning side, I think it's just you've made it so clear cut in terms of, the benefits and the consequences that I feel comfortable kind of transitioning. And if you don't mind talking a little bit about your First and Second Amendment cases and that type of law that you also said you like to handle, if you could expand on that a little bit and share that area with our audience.
Sure. So I'm a member affiliated with several Christian legal groups, the Alliance Defending Freedom, Pacific Justice Institute, Liberty Council. I'm also a referral attorney for several concealed carry associations. United States Concealed Carry Association is one of the big ones. I am a originalist. I am a conservative Christian. I'm someone who I teach. I've taught at colleges. I do speaking engagements often about our constitutional rights, our God-given rights that are supposed to be protected by the Constitution, even though I'm sorry to say that our government has overrun most of those rights. And I've said that if our founding fathers were alive today, they would literally be shaking their heads going, what have you done here? How did you let things go completely opposite of what we intended? So I help on a lot of cases, especially with churches, people who aren't being able to exercise their freedom of religion, their freedom of speech. Mostly are, like I said, religious-based cases because of my affiliation with Christian legal groups. And then I get phone calls from people who say, I had to use self-defense. I had to use my firearm in a self-defense way. What do I do? How do I handle the situation? Police are coming out. I protected myself. I protected my family. What do I do now? So I will get involved in those cases because I firmly believe in the original intent of our founding fathers and what they intended for our Christian nation. And I will fight tooth and nail as much as I'm able to defend those rights.
So, you're based out of Illinois. This podcast is based out of Florida, so I'm sure you're very familiar with Stand Your Ground, which is definitely, a hot button topic in here from time to time. So I'm fairly familiar with laws in Florida. Someone comes into your house, they intend to do you harm. You can prove that they've intended to do you harm. You can take, almost any means necessary to defend your house, your family, etc. Is that something of like the types of cases that you've seen in Illinois and in Wisconsin in the past? You kind of have to enlighten us a little bit because I know, like I said, state laws are different, each state to state. But you take us a little bit maybe through on that path of what you've seen in your experience on that end.
So I can tell you I am displeased with the current legislative branch and governor of Illinois because I do not believe they support and uphold the original intent of our Constitution and our Second Amendment rights. There are some states, Florida, Wisconsin, which do a better job, not entirely, but do a better job than I believe Illinois does. You have to, and actually, I taught about this last night at my church. If you are going to use a firearm, if you're going to defend yourself, you always have to use what I would say the appropriate level of defense against the level of attack that you feel is coming at you. And also, you cannot use, I was teaching this last night, you cannot use deadly force when it comes to protecting your property. So if you're going to say, well, there's an old case years ago, a case where an individual set up a crossbow rigged to, believe his front door. And he knew someone was coming in and robbing from him every time he was gone. And he was successful in finding out who was robbing from him because he killed the person with the crossbow mechanism that he set up. That's not appropriate. That's not proper. The level of force that you use, again, if you feel that if you have a fearful apprehension that someone is going to kill you, then you can use deadly force. If they brandish a firearm, if they come at you with a knife, sometimes if you just, you have the reasonable fearful apprehension that even if they're attacking you to a level that you feel you are going to die, then you are able to use deadly force in self-defense. But if it's a fight, a fist fight, or someone's breaking into your home trying to just, well, when it comes to your home, again, that there's castle doctrines in a lot of states, where if you're going to say someone broke into my home, I was there, my wife was there, my children were there, someone broke into my home, castle doctrine is going to allow you to use deadly force, because you're saying I'm not protecting my stuff, I'm protecting those people inside the home, my family, myself, and deadly force can be used. If, again, someone's breaking into your home, no one's there, they're stealing your stuff, you have to use an appropriate level of force, which you cannot use deadly force to protect your property. You can use it to protect yourself or others through transference, but you cannot use deadly force for property. I hope that answered your question.
It does. I mean, I'm sure it opens up a lot of gray areas, though, when, if it's 2 o'clock in the morning, somebody's, broken through your front door, let's say your back sliding glass door, it's dark. You don't, you can't tell if they're armed, you as a licensed gun owner, in your home. I mean, I think that, that opens up a whole gray area where, they've broken through, your door or your sliding glass window, for example. Where is that, where does that translate in terms of, what's next? And I know we can't predict the future. And I know it might be like a sticky legal area. But it's just, I guess, is it a legal gray area if there's a weapon present on the intruder, then does that automatically, or, shade it more towards protecting your family? What would be some of the things that you would, describe of making it, defending your family? If Do they have to be armed, not armed? I mean, maybe you could clarify that a little bit for the audience.
My litmus test for that is who's home. If you are home, if your loved ones are home, you are with them, and someone's breaking into your house at 2 a.m. and you use deadly force, I will zealously advocate and defend that person. If you're not home, and like I said, the example before, you set up a crossbow or some type of firing mechanism that they break in, open your door, and you've got some tripwire or something that will kill the person, that's not going to be a good defense case. That's not going to be someone who's going to be able, I think, successfully make a Second Amendment self-defense argument. So the test for me is, who are you protecting? And yeah, if they enter your home and so you're home and it's 2 a.m. and everybody's asleep and you hear a glass breaking because someone's breaking in your home, I am going to zealously defend and protect you if you decided to use deadly force against that person who broke into your home with loved ones and yourself in the home. If it's nobody in the home and you use deadly force, that's not a winning case. Then there's questions about, you're in your home. What if you're in your garage? What if you're in your front lawn? It becomes less definite the further you get away from like your living space. But again, the ultimate question is if you're defending a person or you're defending people, then deadly force is appropriate in those situations.
So take it a notch below deadly force, and if there's verbal threats from an individual, maybe a neighbor dispute, verbal threats, there's no firearms or knives or anything that looks like a deadly weapon present, but they're on your property, they're refusing to leave. Okay, so you're not going to use deadly force, but or hopefully not. Now I know we're just dealing a lot in gray areas, and there could be 500 variables, but can you talk our audience through like those type of situations? Obviously, the best situation is just to walk away, disengage yourself from it. But if you do find yourself caught up in a situation where it's a neighbor fight, they come at you aggressively, they're on your property, maybe it's recorded, maybe it's not, but you've told them, back away, get off my property. They're still coming at it and attacking you. What type of stand your ground, even if it's not deadly force, do you typically see? And then, do you typically have, like a range of outcomes for that on the legal side?
So yeah, I mean, one big thing there is if you're on your property and they come onto your property, the person who's the attacker, the aggressor, they just lost a lot of their defense, legal defense, because they came onto your property. You're again, that's more of a castle doctrine situation. If you have, yeah, let's do the scenario. You're mowing your lawn and the neighbor comes over and he's angry because he thinks you mowed a little bit on his side and you didn't observe the property line, and the neighbor's yelling at you and crosses over into your yard, and it's definitely known that they're in your yard and they're getting hostile with you. I'm gonna, again, the best fight you can ever have is the one you walk away from. But the appropriate level of force, if they're just yelling at you, I would advise the person to say, inform them that you're going to be calling the police as they're trespassing and they're showing hostility. If that, enrages them and they come to attack you, you have to have that apprehension. It has to be a reasonable apprehension. They came at you, they're raising their fist. You have a right to raise your fist back and defend yourself. I'm not going to say they come at you, they're angry, hey, you mowed over my part of the lawn, they come at you with a fist and you pull a firearm. You're not going to win that case. That's not a good case. That's not a good decision. They come at you, you inform them that you're going to contact the police to have them come out with the situation of them trespassing. If it makes them even more angry that they are going to attack you, then you can use the same level of force that they're showing in response to, in order to defend yourself.
Okay, perfect. And I hope that, everyone who's listening is really taking heed of that, so that if they're coming at you and they're screaming and they may be swinging, using deadly force against that is something that would be crossing the line legally. It may be morally and ethically, but that's a whole nother podcast that we would get into. But so if you're using excessive force with an individual who's crossed onto your property, the law may not be on your side on that situation if they don't have a knife or a gun or a weapon that they're coming at you with. Is that a fair statement?
Yeah, if you remember the old movie, love this movie, The Untouchables with Kevin Costner, Sean Connery. Yep. There was a line in that movie where Sean Connery said, if you want to win the war in Chicago, they bring a bat, you bring a knife. They bring a knife, you bring a gun. No, that's not the legal standard. That may be the standard for the movie and in Chicago with the mob bosses, but that is not the legal standard. If you're on your property and they cross over onto your property, one, they just lost a lot of their legal defense. They're the aggressor. Two, they are yelling at you. They come at you with a fist, you come back with a fist. They come at you with a knife. You're going to say, well, I'm either going to come back with a knife, or if they're coming at me with a knife and they're very aggressive with it, you may be able to use a firearm in that point and say, a knife was was threatened against me in a way that they could have stabbed me and I would have been very seriously harmed, or I could have been killed. Firearm is going to be appropriate there if you felt that you had a reasonable, fearful apprehension for the safety of your own life. Then you can, again, that's where you're going to say, I can use deadly force. It's obviously helpful if you're on your property. It's just the legal phrase is curtilage. When you're in your yard, when you're in your garage, you're essentially in the curtilage of your house. You're not necessarily in the house. So your legal defense, acceptable legal defense, goes down because of that. If they enter into your home for some reason, and they're yelling at you and they're hostile to you, and they bring a knife or raise a fist, then you have more legal defense when you're inside your home.
Gotcha. And there's one more topic, based off of our previous conversation. I don't know if we're going to have enough time on it, but I know you're possibly open to hopping on again and providing some expertise and a lot of your experience to share. And we've been very grateful for, for the last, 30, 45 minutes. So I do want to be respectful of your time. But
Sure.
there's a very popular issue that's come up, and I'm sure you know it. If you got younger kids or teenagers, Congress is looking at banning TikTok. How familiar are you? I would imagine you have to be somewhat familiar with your expertise in Second and First Amendment. So it's something that I would like us to continue on another podcast. But could you kind of talk about that a little bit from what your understanding is? And to me, not being an attorney, but working with attorneys for years, I mean, am I wrong in saying that? Okay, yes, I get that it's a Chinese company. It could be spying on us. It is spying on us. Whatever you want to, who you want to believe. But by banning that, what type of First Amendment repercussions are we looking at if if that goes through, if that's really implemented, and and we see that, and then what are some unintended consequences that we could see down the line?
So one thing that people don't always understand, and I seem to teach this to people a lot, you need to understand our Constitution was originally intended to protect our God-given rights from our government. So the Constitution was actually written. I've got several quotes from founding fathers where they say, we're doing this, we're writing this Constitution because we want to restrict the government from taking away the rights of the people. So when you say things like, well, they're going to shut down TikTok and, isn't that a First Amendment violation? Maybe. It's a question of, TikTok is not a person. All these social platforms, they're private entities. So I tell people the scenario where, again, this would be a topic for another day for a long discussion, but I was very alarmed and displeased with many things that occurred during the COVID time, where I think the government overstepped its boundaries greatly.
Right.
Now, but at the same time, if I go to a business and they say, like I had during the COVID time, they say, if you're going to come into our business and we are privately owned business, we want you to, show wear a face mask. We want you to show proof of having taken the COVID shot. If a private business says that, they have the right to do that because there's a private organization and they can set their own rules in their private organization. When the government starts saying we're going to require face coverings, we're going to require taking certain medical procedures, that's when you get into a constitutional situation, because you say, well, the government cannot force certain things on people. There's something called, it's a Latin term, it's called an ultra vires act, ULTRA space VIRES. Ultra vires is where you say, if you're going to tell me to do something, show me in the laws, show me in the Constitution, show me where you have the right to enforce that. And if they don't, then they can't. It's an ultra vires act. But that's government compared to private individuals. Now, with TikTok, if we're going to show that, yep, it's being used to spy on our nation and in a situation where another nation is being hostile against us, our government is supposed to be there to protect us from such actions, from aggressors of enemies, defend the borders, which sadly our current president does not do a very good job of. So our government should be defending the borders. If it says that TikTok is being used to spy upon people and we're going to shut TikTok down, I'm going to say, well, the government has a right to defend its borders and defend its people, thus it should. But then you go on the flip side where you're going to say, well, what about the individuals? What about individuals who are using TikTok, social media to say, I'm expressing my freedoms, I'm expressing my freedom of religion, I'm exercising my freedom of speech. Then you say, well, the government just shut that down. well, we got a problem then, because the government cannot restrict our freedom and the government cannot restrict our freedom of speech. There are certain categories where it can. You can't be, as the old Supreme Court decision states, you can't be in the middle of a crowded movie theater and yell fire,
Right.
and get everybody panicking and running and saying, "Oh, I was just exercising my First Amendment rights." You can't have that. But TikTok is a private organization. It is not a government-run organization. People cannot assume that you're going to have the same protections, constitutional protections, in using a private organization platform. So you got the two conflicts of saying, what's more important, that we defend our borders and defend the sovereignty of our nation from an aggressor who may be using that platform to spy upon us? Or is it more important for you to be able to continue to express your freedom of speech and freedom of religion, but it's not on a governmental platform? So
Yeah.
the answer to that is it'll be up to the Supreme Court, and I believe it'll probably go that route.
And I think that would definitely be a continued conversation, hopping back on here, and kind of revisiting that, and then and talking a little bit more, because again, Vertical 10, we're a digital marketing company, so Facebook, Google, Instagram, that's a big way in which we promote our attorneys, and along with what we're doing now with Apple, Spotify, and the podcast. So it's always concerning and interesting to watch that, and to have you hop on with your expertise is definitely appreciated. One thing I know we're running over just on time, so I do appreciate it. But one thing just kind of want to wrap up on, and we ask a lot of attorneys on this. So at your stage in your career, how do you see the next 10, 15 years playing out, for the spectrum that you're living in, you're working in? We've got AI, we've got technology, just exponentially expanding on itself, what seems like every day. Where do you see how you're going to get clients in the future, how you're going to deal with clients in the future? How is technology gonna impact you and your firm, let's say, over the next 10 or 15 years? What do you see coming down the road as a kind of a way to wrap up this podcast, and hopefully we hop on again, to continue expanding on some of the topics that we touched on earlier.
Sure. One of the, I guess I would say, positives of the COVID situation was people started to realize, oh, I don't have to go to court, actually, like physically be in the courtroom. I can put my camera up, and they can put cameras in the courtroom, and yep, I can talk to a judge on a Zoom camera just as much as I can talk to them face to face. It's not the same, but you can get a lot done. I haven't been inside the courtroom now. It's probably several years. Most of the hearings and everything I do, yep, I log in and I go online and I attend the hearings and I attend matters just sitting in the comfort of my own office. So I see it going that way quite a bit. The challenge for me, and I don't see a good answer to this one, I don't know how they're going to address this. As primarily an estate planning attorney, estate administration attorney, when I meet with people and I have them sign their wills, I have them sign their trust, I have them sign their powers of attorney or living wills, you have to have the people sign. There have to be witnesses, and there has to be a notary. So I know there's a lot of like DocuSign. I've had entire real estate closings where I never met the person that I represented face to face. Had a lot of phone calls with them, had some Zoom meetings, did the closing on their behalf as a limited power of attorney. And I'll be honest, I very much enjoy that. It's it does make it a lot easier. But the challenge that I see that I do not have a good answer for, and I don't know what the game plan is how are you going to have people sign a will, sign a trust, sign power of attorney with a witness being able to be there to say, yep, I see them signing, it's of their own accord, they're not under duress, they're not being forced, they're not being threatened to sign these documents. And yep, I saw them sign it, and sign it with, how can you do that with a DocuSign? How can you notary stamp that? Those are challenges that I see being problematic. Don't get me wrong. I am, like I said, licensed in Illinois and Wisconsin. I would love to be licensed in Florida. Florida, unfortunately, and I do not appreciate this, Florida is one of those states of several that say, if you want to practice law here, you have to take a bar exam here. I think that that's ridiculous, especially with someone with, I've been practicing law now for 23 years, 22, 23 years. I would love to get I don't have time to sit and study for a bar exam again. That's a full-time job in itself.
Right.
I would prefer to get reciprocity, be allowed to practice in Florida, or other states. But if they come up with a solution saying, well, here's how people are going to sign things from anywhere and have them notarized and have them witnessed anywhere, more power to them. Because if I could be residing in Florida, not in the Arctic, the frozen tundra of the Midwest,
Right.
but residing in Florida and still helping my clients in Illinois, Wisconsin, fantastic. I would love to be in that scenario, but it just hasn't come up yet.
So, quick little fun thing at the end. Packers or a Bears fan? I know you're right in the middle between Milwaukee and Chicago.
I was born and raised in Wisconsin, so yep. If I get a paper cut, it comes out green and gold. So I love the Bears. Are you kidding me? I love the Bears. They've given us so many wins over the past 20, 25 years. It's fantastic. When the Bears used to have Jay Cutler, he was my MVP.
Yeah.
That guy gave more touchdowns to the Packers than I think most of the Packer players did. So.
Well, yeah, no, it's Aaron Rodgers owned the Bears, and now it's looking like Jordan Love's going to own the Bears. So I know with the draft, Caleb Williams may have something to say about that, but yeah, we watch from from Florida, and it's when the Bucks play, it gets overrun with Packers fans. Packers fans overrun almost any stadium. So, but yeah, absolutely. But yeah, just I noticed your office is pretty much smack dab in the middle. So I was just a little question to end to see which side of the fence you stay on. So no, absolutely.
Yep, I'm loyal to my Wisconsin teams. So
yep, completely understand. All right, Jeremy. Before we wrap up, if you don't mind. Telling everybody out there where to find you, how to find you, your website, the best contact number, best email address where they can reach out if they've got any questions, if they're in Wisconsin or Illinois, and they do need services that your firm provides. If you don't mind just taking a second and just letting everybody know how to find you.
Sure. I am in the process, I told you before, of updating my website. It's a little dated, so I'm in that process, but my law firm website is www.theramseylawfirm.com, just one word, theramseylawfirm.com. That's my website. My email address, I've had it for a long time, attyramsey@yahoo.com. So like attorney, but abbreviated atty Ramsey, RAMSEY @yahoo.com. And phone number is 815-988-4364.
Okay, perfect. Jeremy, thank you very much hopping on the pod today. Just outstanding insight, outstanding conversation. We really appreciate that. And if you are a Bears fan, still reach out. He will help you. Don't hold decades of beatings against Jeremy. He wasn't playing running back for the Packers last year.
Right.
He's not related to Aaron Rodgers that we know of. So, but in all seriousness, we definitely do appreciate you hopping on. We would love to have you as a guest again. There's hundreds of issues that we could talk about, where I think your experience, your expertise would be a big benefit to our listeners. So if that's something you're open for, we'll set up another podcast and kind of talk about what's going on. Example today, like with TikTok, but as events come up, I think your insight would be definitely valuable for our audience.
I appreciate that. I'd be happy to be on again.
Okay, perfect. All right. Well, thank you very much. Again, this is sponsored by Vertical 10. You can find the Next Level Law podcast anywhere where you find your podcasts, Apple, Spotify, etc. Thank you guys very much for listening. Jeremy, thank you. Have a great day.
Thanks, you too.
All right, take care.
That's a wrap for this week's episode of the Next Level Law Podcast with your hosts, Arash Eskandari and Richard Perillo. We hope you discovered some game-changing takeaways to implement immediately for leveraging your law firm growth. If you enjoyed the show, please leave a review and rating on your preferred platform to help get the word out. You can also visit vertical10.com to access free law firm growth resources and a free copy of Arash's book, The Law Firm Marketing Blueprint. Finally, remember to join Arash and Richard next time as they continue revealing their best strategies for taking your firm to the next level. Until then, here's to your success.